Hi, I'm Attorney Charles Barron. My office address is 2645 Northeast 207th Street, Suite C, Aventura 33180. I'm here tonight representing 4 people. Deborah Bakar, Alon Bakar, who are here tonight, plus myself, plus my wife, Dr. Ino Jauer Barron, who is not here tonight. And I first like to ask you, Mr. Mayor, that I may need a little bit more than 3 minutes as an attorney, and I discussed this with Darcy this afternoon. Not much more. I know this is first reading.
Just speak. Just come on.
Okay.
You're already wasting time.
Mr. Barron, I'll give you a little bit of extra time. Please get started.
Yeah, thank you very much.
Thank you.
All right, I'm going to hit on some substantive points as well as a procedural point, starting with the substantive. I should mention that my clients, Deborah and Alon Bakar, live at 2330 Northeast 174th Street. They live 2 to 3 blocks away from the proposed rezoning at 17071 West Dixie. I reside at 17890 West Dixie, just up the street from the subject lot. And I'd like to first ask all of you council members here a question, and that is, in your tenure here as council members and as mayor, have you ever seen a rezoning application by the owner of the property who has no plan whatsoever for what they would like to do with the property or what they might do with the property? Have you ever seen that in your career as council members?
Mr. Barron, no one is answering that question. Please go ahead and make your comments.
Well, okay. Obviously, the answer is no.
Mr. Barron,
well, then I'd like to,
Mr. Barron, you don't get to ask questions here.
Right,
Please
fine.
make your comments,
Okay.
and I hope they will be substantive comments. Thank you.
Yes, they will. Thank you. Now, the planning file indicates that this landowner, who has not contacted anybody in the neighborhood, apparently, wants to, quote unquote, explore opportunities that may arise when a Hyatt hotel goes up the street. How can they explore that opportunity? As you know, that other rezoning is in hot and heavy litigation right now, and it has been for 9 months and no end in sight. If we lose that litigation, it's going to go into appeal. This litigation is going to be lasting at least another year, unless, of course, we all sit down at the bargaining table and amicably work something out, and then you could start earning your tax revenue for the city and have a good development that everybody likes. Had that been done way back, ground would have been broken already on that project, and you would have been well on your way to earning that tax revenue. But instead, it seems like the landowners in this city want to wage war on the neighbors, and it's their way or the highway. All right? Let's you all not encourage this war. Let's encourage amicable resolution. I urge you to vote against the B2 rezoning, or at least table this until this owner comes up with some sort of plan. If not an actual site plan drawing, then something in writing as to what they would like to do with the property, so that the neighbors in the neighborhood can review that and determine if that's something that they could easily live with. Maybe they are planning something that the neighbors could easily live with. We don't know that. It looks like this is entirely a speculation, just to make a buck, maybe rezone it and then flip the property. How's that going to help anybody, except that landowner, of course? Mr. Ullman already went over, Attorney Ullman went over the zoning ordinances that regarding consistency and in scale with the established neighborhood land use pattern. I'm not going to elaborate on that, but that's obviously an important issue. B2, there's no B2 anywhere on West Dixie Highway. You have the one B2 rezoning that is now in litigation and may not happen. All right, now, substantively, the Jennings rule. And this is what I brought up last September with you all on the other property. Your own code says in resolution number R95-24, section 2D, any ex parte communication or activity received or occurring regarding an anticipated or pending quasi-judicial matter and not physically made a part of the record on file, meaning written and in the file, with the city and available for public inspection prior to the public hearing on the matter shall be orally stated and disclosed on the record at the public meeting prior to the vote on the matter. Persons who have contrary opinions to those expressed in any ex parte communication shall be given a reasonable opportunity to refute or respond to the communication. You have not done so tonight. I object for the record. That will be an issue in litigation. And I realize that for you to first sit in a meeting with a lobbyist or an objector and write down the substance of that conversation is time-consuming and burdensome. I realize that. But that's what your code requires, and that code was enacted pursuant to Florida statute. There's a very easy way to avoid that burdensome, time-consuming task, and that's not to meet with anybody before the quasi-judicial zoning hearing.
Mr. Barron?
Yes.
I've given you like 6 minutes now. I think we got your points.
Right.
I need to move to the next speaker.
It's fine. Let me finish my sentence, please.
Okay.
Okay. That's it. Quasi-judicial hearings is what you have here. You're sitting in judgment on a zoning application. This is not you all coming up with a proposal to enact something. You're sitting in judgment. In quasi-judicial hearings, you need to be impartial, and the best course of action is just not to meet with anybody in advance. But if you do, you need to follow your ordinance. You're not following it, I object. Thank you.
Thank you.